Hey, it's Ben. Rahul and I started this podcast because we love hanging out with fellow trial lawyers and sharing ideas that can make us all better. And both of our firms also regularly collaborate with other lawyers across the countries in cases where we can add value. If you're interested in collaboration, or even if you just have a case or an idea that you want to bounce off us or brainstorm, Rahul and I are going to be hosting confidential case workshops the first Wednesday of each month. So here's how it works. If you have a case or an idea that you want to talk about or brainstorm with us, just send me an email to ben@elevate.net, ELAWVATE.net, or go online to elevate.net and submit a case workshop request. We will schedule you for a confidential 30-minute Zoom meeting where we can talk about your case to see if we can help. If you feel like there would be good value in collaborating on the case further, we can talk about that. If not, that's okay too. We enjoy helping other trial lawyers because we know someday you'd be willing to do the same for us if we needed your help. So again, if you're interested in workshopping your case with us, just send an email to ben@elevate.net or fill out a case workshop request at elevate.net. And Rahul and I will look forward to chatting with you soon. This episode of the Elevate podcast is brought to you by FileVine. FileVine has a software program called Lead Docket, which is the gold standard for managing your new case intakes and leads, your Glenn Gary leads, your Glenn Ross leads, and all of your other leads. So check them out at FileVine and manage your leads. We're also brought to you by Steno. Rahul, you guys work with Steno?
Steno is the best in court reporting services, not just in court reporting services, but even some of their technology tools. We're talking about AI a little bit on this podcast, and their transcript genius, where they can summarize and take interrogatories based on deposition transcripts, is so useful. If you haven't tried it, definitely try it.
We're brought to you by Hype Legal. Hype Legal does digital marketing, web development for trial firms. It's owned by our good friends Micah and Tyler. They recently redeveloped our firm's website, so you can check our website out. If you like it, give them a call, and they can help you out too. And finally, we're brought to you by Expert Institute. Rahul, you guys work with them, right?
We both use Expert Institute because you always need to be cutting edge in the experts that we use in our cases. Going to the repeat experts every single time is going to make you a lesser lawyer, and you always want to keep up, and the best way to do that is with Expert Institute. Welcome to the Elevate podcast. I'm Rahul Ravipudi.
And I'm Ben Gideon. Rahul, so you're waiting on a jury. Tell us what's going through your mind.
I'm super excited. So this is on the social media addiction cases, and it's the first bellwether trial. And we represent a young girl, KGM, Kaylee, who got addicted to social media, starting with YouTube, and then it carried on into Instagram, and suffers from body dysmorphia, depressive disorder, social anxiety, and a number of other issues. And this is the first trial in the country that started, and it's gotten a lot of press, which is fantastic for really what the point is, which is to get the message out there and to really shine a light on the defendant's conduct, and really intentional conduct in addicting and harming kids. So the jury's been deliberating for 3 days now, and there's been questions, and I'm feeling optimistic that they're going to do the right thing.
Well, good luck. We've all been following your trial, and it's a really important case. And we'll have to circle back after we get a verdict. And I'm really interested in hearing how everything went from your perspective, but I know it's a little premature, so we'll do that.
Yeah, it definitely is. But I already know right now that we made a difference. And even bringing the litigation and the things that have ensued since, the U.S. Attorney General issuing a warning that social media is harmful for children, the awareness and forcing these companies to start putting in safety controls, which they didn't do. And none of them are effective, by the way. These guys, they really these huge technology companies, these trillion-dollar businesses, they know exactly how to not make things effective and to make things incredibly potent when they want to. So, and then I don't know if you saw, but in Delaware, the judge in a insurance coverage issue for Meta found that there's no coverage for their conduct in these cases because their conduct was intentional in designing their platforms to be addictive. So, there are so many different forums which are really reaching the same conclusion on how bad these defendants are.
Wow. Well, we're thrilled to have on the podcast today Deepak Gupta. Deepak, I met you for the first time in Nashville and heard your talk there, which was incredibly impressive. I know you're also involved in these social media cases, right?
Yeah, we're handling the Section 230, the defense that the tech companies have been asserting on appeal, and really just grateful that you guys are having me on, Ben and Rahul, and Rahul especially with taking time in the middle of a really important moment and such cool litigation that you guys are working on.
Well, it's just a moment for me, but Deepak, you do incredibly important and large impact issues every single day in the work that you do. So I hope all of our listeners know, but we're getting to spend some time with what I think is the best appellate lawyer in the country. And so it's fantastic to get to speak with you today. It was awesome seeing you at the Inner Circle meeting in Nashville. But I mean, a lot of the work that you do, Deepak, really has been influential in protecting consumers' rights and victims of corporate negligence rights. And so I'm just personally grateful for all that you do.
Thank you so much. I mean, same back at you. It's you guys are amazing trial lawyers. I'm a fan of this podcast and excited to talk to you guys.
So Deepak, I mean, one of the things that's so interesting about you is you sort of invented a job and a career that didn't, as far as I know, didn't exist before. Not many people do that. How did you figure out this line? I mean, you came through different public interest and policy related legal jobs, but how did you get to this point of having this really impressive and quite successful dominant plaintiff side appellate practice, specializing in Supreme Court litigation of all things?
Yeah. So I certainly didn't plan to get into the kind of work that I'm in now. I think when I was thinking about law school, I knew I wanted to do public interest law. Initially, for me, that meant civil rights and civil liberties. And then I went to a place called Public Citizen, that's a consumer advocacy group, and they had a wealth of knowledge on Supreme Court litigation for years. They had been representing the little guy in the Supreme Court and had recognized this increasing kind of advocacy imbalance. That on the one side, you have an increasingly specialized Supreme Court and appellate bar representing corporations. That really started to pick up steam in the 1980s when you had people from the U.S. Solicitor General's office go over to corporate law firms and start these practices. And in the 80s and the 90s and into the aughts, it became a real powerhouse on the other side and started to really disadvantage plaintiffs. And, plaintiffs, there are all sorts of biases that appellate courts may have against plaintiffs anyway, and then having that kind of specialization. It was clear to me in those early years of my career at Public Citizen that there was a problem, that there was an imbalance. And I was doing appeals with lawyers around the country and started to wonder, shouldn't there be a kind of private counterweight to the appellate bar on the corporate side? So that idea was kind of planted early, that seed, but it took me a long time to figure out how to do it and when to do it in the right moment. So I had argued a case in the U.S. Supreme Court, AT&T versus Concepcion. Then I went, when Elizabeth Warren was starting the Consumer Financial Protection Bureau, I went there to be the first appellate lawyer to help set up that bureau. And it was kind of only after those experiences that I thought, oh, this is like kind of the right time to hang out a shingle, which is like a scary thing to do. It's scary enough for somebody to hang out a shingle, but to hang out a shingle, as you said, in a practice area that kind of didn't exist, and I didn't know what whether the economic model would work, and so I really came to the point where I realized the only way to figure out whether this is going to work is to do it. I had by that point talked to a lot of people. I figured out that there were people decades earlier who had realized there was a problem, had tried to set up a firm to do this kind of thing and hadn't quite made it work. And so I tried to figure out what were the mistakes people had made, what was the right way to do this. And, that was in 2012 that I started this. And it's really been a dream come true. I think I'm just really fortunate to have a bunch of amazing colleagues who are not just amazingly talented lawyers, but are terrific human beings to do this with. And that's one of the best things about starting and running a firm, is just to work with people that share your values, care about each other, and are engaged in a common enterprise where we are really a mission-driven firm. And I don't know, I have to pinch myself.
So if you summarize your firm and your mission for everybody, what is it?
I would say that, we are a Solicitor General's office for the plaintiff side. So for those who don't know, the federal government and the states, they all have a Solicitor General. And even though the U.S. Justice Department has like 1,000 lawyers, they have a very small office that handles the Supreme Court work and oversees all of the appeals that the federal government is engaged in across the country. And the defense bar has their Solicitor General's offices. And so what we wanted to do, and what we have done over the past 14 years, is construct a counterweight on the plaintiff side for the full range of issues in plaintiff's practice, from personal injury to antitrust to civil rights, class actions. So substantively, we're working on a really broad range of things, but the mode of advocacy is extremely specialized. It's always briefing and argument and working collaboratively with trial lawyers across the country. So we're in the U.S. Supreme Court. We are in state Supreme Courts. We're defending large verdicts. We are fighting tort reform. It's a broad range of activity, but it all stems from that kind of specialized mission.
Before we get into some of your specific cases and issues, I'm just interested in the difference between the skill set required to be a highly effective appellate lawyer versus a trial lawyer. It's something I've always thought a lot about. It strikes me you have a very nimble mind. You're very quick on your feet. You'd probably make a good trial lawyer, but you've elected to go into a different path of appellate law. Do you think the skill sets are the same? Are they different? Are they overlapping? And what's the distinguishing quality that makes a good appellate lawyer?
Yeah, it's a great question. I do think there are lots of overlapping skills. And, some of the time when I have done trial-like activities, it's not my focus, but I realize, wow, this is fun. And I think I could be good at this. And I wonder what would have happened if I had, decided to be a trial lawyer. And I'm sure, lots of great trial lawyers have the same experience when they do some appellate work. A lot of what we do is very in common. So we are telling stories. We are, distilling complex problems down into simple narratives, whether those narratives are about the facts or about the law. So there's a lot that's in common. Of course, the audience is fundamentally different, right? And I think a lot of it boils down to that the kinds of people who maybe are terrific at persuading, a bunch of randomly chosen people might be different than people that are good at persuading a bunch of randomly chosen judges. But a lot of that just has to do with focus. You all have spent how many hours like honing your trial skills and thinking about how to connect with juries, how to select juries, how to tell stories to them, how to marshal the facts. People who do what I do have spent, decades doing the same thing with how to connect with groups of judges who are deciding things not just about the particular case, but about what the legal rule is going to be for, the whole country or a whole state. And that ultimately ends up being, even though the skill set they may have a common nucleus, ends up being a pretty difficult, different enterprise. And so I think ultimately they are, two different specializations. That doesn't mean that people can't be terrific at both. I think it's pretty hard, though, because I think both of these things are pretty hard. Trying cases to juries is pretty hard. It takes a lot out of you, and it takes a lot of work to get good at it. And I think the same thing with, arguing a case to the U.S. Supreme Court. I see that each time I do it, I get a little better. There are things that I learned from the last time. And so, and then the other thing is like writing and research, and those kinds of skills and activities are much more central to what we are doing. Everyone likes to focus on the oral argument because it's what you can see and it's kind of dramatic, but it's a lot less important relative to the whole decision-making process compared to a trial. So, in trial, what happens at trial really is critical to persuading the jury, whereas in an appeal, as much as I like to think like I put a lot of work into refining my oral arguments, I think really it's what happens on the page that is the most important. And that's a pretty big difference between what you guys do and what I do.
What do you think on all of the issues you've argued before the United States Supreme Court? Is there any example of where you feel that your oral argument is what moved the needle on the ultimate decision?
Yeah, I think so. I mean, I think actually, I'm the wrong person to ask because I'm always going to want to think, just like you guys, I'm sure think that the things that you say to juries are what moves the needle and not just like the facts of the case that were there before you got there. But yeah, I argued two cases in the U.S. Supreme Court last term where I felt like nobody really knew what was going to happen at argument, and I persuaded the Supreme Court to dismiss both of those cases after argument, so like not to decide them at all. And there were both cases where corporations had taken these issues to the court. One was a securities fraud case. One was about whether you need to prove injury in class actions at the certification stage. And we like kind of blew the cases up. And I think it really wasn't until argument where, I was able to say, like, there's really nothing to decide here, that we knew what would happen. So, but that's a very self-interested thing for me to say. I'm sure, like, I'd like to think that I moved the needle. Maybe the justices were inclined to do that regardless. I don't think so, but don't you have that same feeling? Like you like to think that, what you said to the jury was the thing that really made the difference, right?
Well, in our case, it always is.
Yeah.
And then you've got to figure out on appeal how to support that crazy thing we said, right?
Yeah. Well, that's one of my favorite things to do is to argue in support of jury verdicts. I love doing those appeals because, they're always a case where somebody did something bad. It made a jury mad. Somebody was hurt. There's a lot at stake. And I get to tell the story. This is like to what we were talking earlier, like I'm telling a story, but it's a really different way of telling the story, right? I'm trying to distill down the things that probably at some level got the jury upset about the conduct. But judges are not people that want to feel like they are being persuaded based on their emotions. So they're human beings and they have emotions, and those emotions and feelings certainly influence their decisions, but you can't you can't write the appellate brief in a way that seems like an overt appeal to emotion, right? So you're taking the story that was told to the jury and distilling that down in a really different way. And I love working with trial lawyers to do that on appeal.
So one of the, distinguishing factors that we have versus your arguments in front of the justices is we don't get any feedback from our jury as we're making our arguments, right? So we do it and then we hope that things resonate. You get feedback, but then you also kind of know your audience a little bit better based on, even if it's your first time showing up, you've seen their prior decisions and opinions. And then if you're showing up in the Supreme Court, you've argued in front of those people before. How much of that plays in? So, I mean, I'd imagine that even before you show up in the Supreme Court, you go, okay, I think I know which justices I need to persuade the most on this issue. And do you craft your briefs to with that in mind, and then prepare your oral argument with that in mind?
Yeah, absolutely. I mean, the great thing in the U.S. Supreme Court is your panel, right? It's the same people. We know a lot about them. If we're in a court of appeals where there's a random selection, you have to kind of brief the case for the whole court, for all the potential permutations of judges you could get. And we try to imagine the most hostile panel and try to, figure out how to persuade that panel. But in the U.S. Supreme Court, yeah, we know so much about these people. They have so much writings, so many writings on the topic, and we can make pretty strong, educated guesses about where they may be coming from. And then, as you say, you get real-time feedback, and that's so critical. It's not just like what they're saying; it's body language, it's mood. During the pandemic, I argued a case in the U.S. Supreme Court by phone, and so I couldn't see the justices, and that really brought home to me how different it was, because you're just missing so much feedback that you get that's nonverbal feedback. And you're really trying to read the room and have a conversation, not just with the person that's asking you the question, but with the entire bench.
I remember when you were speaking in Nashville that I was very interested in the way in which you were thinking about the philosophy of the individual justices, particularly with more conservative leaning judges on the U.S. Supreme Court now, and trying to figure out how to present plaintiffs' issues in a way that was resonate with them. And you had some really creative approaches to that. How important is it in what you're doing to think not just about the analytical side of the argument and the intellectual side, but the kind of political philosophy that the decision makers are coming from, and how have you managed? Because now we do have more and more Republican appointed judges that may be somewhat hostile to plaintiffs' cases, generally speaking, but you're finding a way to come up with a way to present these issues that resonate. How are you doing that?
Yeah, I mean, I think that's crucially important, Ben. And in some ways, like my whole career, I've come up in a conservative judiciary, at least at the federal level, right? You had the Rehnquist Court, you've got the Roberts Court, but now we have a 6-3 conservative U.S. Supreme Court. So it is malpractice if you're going into that court and not thinking about what are the arguments that I have that appeal to people who are really committed to the conservative legal movement. You have to kind of make those arguments. That's going to differ in, if you're in a state Supreme Court, it's really very, specific to the forum. And so we spend a lot of time, really, really thinking hard about that forum when we're in, various state courts around the country. But in the U.S. Supreme Court, like I said, we know, 6-3 court, that doesn't mean that they all march in lockstep, but they have various commitments to things like originalism, textualism, their feelings about the role of the civil justice system in the economy. And we think really deeply about how we can appeal to those commitments that they have. And I think people are continuously surprised about this, because a lot of people's perceptions of the U.S. Supreme Court are really largely shaped by a really small number of cases that are the cases that the media talks about, right? So the really highly politicized cases, there are only a few of them each term, and they tend to break down along predictable ideological lines, or the shadow docket cases increasingly. And those cases, like, they're the least interesting cases to me from an advocacy perspective. We know how the movie ends. It doesn't end well, and so I don't really want to be spending a lot of our time on those cases, and they're orthogonal to our mission. Our mission is about protecting the civil justice system and standing up for consumers and workers. And this is the crazy thing. We actually have a pretty good shot in our cases in this court if we're careful about the arguments that we select and the cases that we select. And just, one set of data points, over the last 2 terms in the U.S. Supreme Court, our firm has had 7 arguments, and we have a higher win rate in those cases than any other law firm that, was in the court as much as we were. So of the top 5 firms in the U.S. Supreme Court, we had the highest win rate, and that the other firms are all large corporate law firms representing, corporations that have done bad stuff. So how do we do that? We do it, by appealing, sometimes it's methodologically, to conservative commitments. So, for example, we have a series of cases about forced arbitration where we're representing workers, and we're interpreting the original meaning from 1925 about this exception for workers. And it turns out if you go back and you take the history really seriously and you do a deep, deep dive into the history, which is what one of my colleagues, Jennifer Bennett, has been doing in her cases, we can win. And we've won a series of cases unanimously for plaintiffs against forced arbitration, which, I think most people think the rule is just that the plaintiff always loses in those cases in the Supreme Court. And we've won cases about class actions where we go back to, might sound silly, but we go back to, what was the law in the late 18th century? What was the most analogous law surrounding class actions? And there were cases about, people on ships who needed to collect a prize, a bounty, and all of the people on the ship were a class. And we make arguments about how it would have worked back in the late, 18th century, and that appeals to someone like Justice Gorsuch. We had a case about personal jurisdiction in the Supreme Court a few years ago, and I think the prevailing view among civil procedure professors and lawyers was that the plaintiffs always lose in those cases, and that was true going back to the 80s. But the current justices are actually open to reconceptualizing personal jurisdiction and bringing back some common sense. So I'm not like,
is that the Ford Motor Company case?
Yeah, that's the Ford Motor.
Can you just explain to us what the current status of personal jurisdiction is? Because it's something that we have to deal with a lot.
We do a lot of work on personal jurisdiction. So, back when I was in law school, right, all of those cases were about basically how the plaintiff gets kicked out of court because they have sued in the wrong forum. And a lot of it is about forum shopping. A lot of it is about narrowing both specific jurisdiction, the jurisdiction that is tethered to the, related to the claims, right? Or general jurisdiction that, is conceptualized based on the defendant being at home in the jurisdiction. The Supreme Court was cutting back on both for decades. And then this Ford case comes along, and it was actually 2 cases, one from Montana, one from Minnesota, and both were pretty garden variety car accidents that produced products liability claims. And in each case, the person, the person bringing the case was injured in the state in which they resided. They had purchased the cars where they lived, but they were used cars. They came from somewhere else. And so from Ford's perspective, hey, we didn't do anything specific to this case in your state. We designed the car in a different state. We manufactured the car in a different state. We sold it to someone in a different state. So how can you say that our conduct in the state caused your accident? And if law were a computer, like a computer program that you just inputted an argument into, and then it logically followed all the prior precedent, if you have just lawyer brain, Ford's argument made a lot of sense. It might have even been the sort of logically correct output of all of the prior cases. But if that's the logically correct output of all the prior cases, then something is wrong with the jurisprudence, because that makes no sense. If you talk to any person who's not a lawyer and you say that the law is that, there's a car accident and someone is hurt where they live, and it's a big car company like Ford, the idea that you can't sue them there, even though they're selling tons of the same car in that jurisdiction, that just makes no sense. And so the approach that we took in Ford was basically, first we had to tell the Supreme Court to set aside all of its prior precedent, essentially, to say that the prior precedent really wasn't about this question, and to try to locate the analysis on the person's residence and the site of injury, which is not what the court had previously done. And so a lot of it was just about, and I think this is a big difference between Supreme Court advocacy and advocacy in the lower courts. A lot of it was about the practicalities of it, whether it would make any sense. We also emphasized state sovereignty. We got it, most of the states, state attorneys general, to file a brief on our side, including very conservative states. And we really tried to depoliticize the issue. We tried to show that it was bad for American Main Street businesses if you can't sue a foreign corporation based on this theory, and then the American companies get left holding the bag. So, try to show that it harms states, it harms businesses, it makes no sense. It would multiply litigation, because you'd have to sue in multiple different courts just for simple garden variety product cases. And we ended up winning that case unanimously. I mean, there's some separate writings by Justice Alito and Justice Gorsuch, but they all agreed with the result that we were pitching, and the court adopted our test. And the test is really simple. It's, if a company is selling a product into a state, and that exact same product injures someone, then there's personal jurisdiction, regardless of whether there's a direct causal relationship. Now, since that decision in the last few years, courts have been disagreeing about whether companies can evade personal jurisdiction by placing restrictions on uses or the purchases of their products. So there are a whole bunch of cases involving exploding lithium-ion batteries, and these Korean companies that sell the batteries that are exploding like in people's pockets. It's very dangerous, and people get really bad burns. They're saying, well, we sell those batteries, but we sell them for packaged products, drills, laptops, cell phones, whatever. We're not selling them for people to buy them and vape with them, and that's what's causing the injuries. And so we just filed a cert petition in the U.S. Supreme Court this week about that issue, about whether or not it's a mistake to draw an exception from Ford based on restrictions that companies place on their products.
I just
sorry, I don't know that was too much.
No, it's really. I mean, this affects a lot of our listeners, I'm sure. So it's good to have a primer on personal jurisdiction again. And thank you for getting that result. I think that's going to help a lot of claimants.
Yeah, I love that case. Well, what's so cool about it is like to have a case like that. It means it's going to be in every civil procedure casebook. So like every law student is reading a case that you worked on, and it like mirrors the test that it doesn't get any better for an appellate law nerd. It doesn't get like much better than that.
So awesome. Okay, so from the appellate law nerd to the appellate no knowledge baseline guy, I want to kind of take a couple of steps back and maybe provide some inspiration to the public here, because as a layperson, which is what I treat myself as when it comes to the Supreme Court, I feel like they are outcome generated. And maybe it's because what I'm reading is mostly media based. And what I'm hearing from you is that with your win rate and that the way of framing things, whether it's originalism, textualism, which I don't know the difference between, how can you tell everybody how these 6 conservative justices are not outcome generated, and how any issue can actually get framed in front of them, and they'll stick to their whatever their core beliefs or interpretation processes are, and you can win.
I didn't say any issue, Rahul. So that I think
I'm
I
going
think
with
that
Eddie.
I think that for some issues, look, for some issues that are highly politicized and that where people are fighting the culture wars, this is what I was alluding to earlier. I think the outcome may be foreordained, and I think the best way to think about this is that the Supreme Court is both a political institution and a court, and so sometimes for certain cases, if you're on the vibes docket or increasingly on the shadow docket, you know, the case may be more about kind of the prior commitments that the justices have, and the legal advocacy maybe plays less of a role. But we, as a firm, we try to stay on what we call the law docket. And the law docket is the set of cases at the U.S. Supreme Court where the legal materials are truly relevant to the decisional process. I mean, these justices, they are also very talented lawyers. They have really talented lawyers who are law clerks, and they are trying to do law. And I think that gets lost, because people are focusing on a small subset of the cases. Look, we have no choice, right? This is the court that we have. We have clients. These, issues matter. What the U.S. Supreme Court decides about the civil justice system and access to the courts, it matters for our clients. And so we have to, we don't have any choice. We have to make the arguments that are most likely to persuade them. And I think, what our record shows over the past few years is that it is possible that if you make the legal arguments, you take them seriously. It also means not being delusional. I mean, we take a very defensive posture to a lot of cases. My favorite kind of brief to file in the U.S. Supreme Court is a brief opposing a cert petition, try to keep cases out of the court and preserve wins in the lower court. So I don't want to suggest that it's the greatest court in the world for plaintiffs or for the little guy. What I'm saying is that if you are strategic and you take them, seriously as a court, you can win, and we've shown that, and I think you can extrapolate that lesson to courts around the country where there are judges that are, to varying degrees conservative or have defense backgrounds. You can make arguments that can appeal to judges with different orientations, and you have to. And I think you guys know that because you do it all the time when you're trying cases. You try cases sometimes in pretty conservative jurisdictions, and you make your arguments differently. I know you've talked about that on the podcast, right? It's not fundamentally different.
So did you say the vibe docket?
The vibes docket,
What's
yeah.
that?
Yeah. So I would say that there are cases where the court really is, and I think this is a lamentable development. I think the court should stay out of these kinds of things, but the court increasingly just cannot resist jumping into the cultural, political controversies of the day without allowing the lower courts to kind of flesh out the legal rules. So they jump into debates over bathrooms in schools and just every hot button issue, it seems now, gets to the Supreme Court faster than it would have decades ago. And I think that's a mistake. I think the justices are not doing themselves any favors when they do that, because it's bad for the public perception of legitimacy of the court.
So on one of those vibes docket cases, those are the ones that sound like they're the politicized ones that may lead to an outcome generated decision. Have you seen a decision where you, Deepak Gupta, looked at it and go, okay, I could have moved this from the vibe to the law, and then the outcome could have been different? And is there like a real life example you can talk to us about?
Yeah, I mean, I think I can give you one example it's where we actually did this in the past year. We just got a unanimous decision from the U.S. Supreme Court in a case where I think if you take the public perception that people have, they would assume we would have lost. Our clients are immigrants who are detained in an ICE detention facility run by a private contractor. There's this company called Geo that runs a lot of private detention facilities for ICE. And our claims are that the workers, the immigrants are being forced to work in the facility, do things like clean toilets, and they're not paid. And so, we were bringing claims and there's litigation like this around the country. But the legal issue in the case was whether or not this private corporation running the detention facility could get what they called derivative sovereign immunity, whether they could enjoy kind of the sovereign immunity that ICE would have because they're a private contractor with ICE. And we had this sense that they had gone too far with that argument and that even the federal government wouldn't agree with that version of that argument. We got the Trump administration on our side in this case. And the court ruled unanimously in our favor. And I think that's just like a good example of if you take a knee-jerk reaction that, look, there's no way with those clients in that kind of case that we could prevail, that does a disservice to the clients, because actually sometimes the law matters is what I'm trying to say.
Take your playbook to the next level by joining a legal network of all-stars at psrplaybook.com. psrplaybook.com is a free digital legal library created exclusively for plaintiff lawyers by the nationally recognized personal injury law firm of Panish Shea Ravipudi LLP, and features video content showcasing the tactics, strategies, and concepts implemented by some of the industry's most successful trial attorneys. PSRplaybook.com promotes learning, shared knowledge, collaboration, and best practices. Get in the game and see for yourself by joining our national network of plaintiff lawyers. Subscribe now at PSRplaybook.com and learn from the best.
Deepak, does your firm ever get involved earlier in a case before the verdict or decision on dispositive motions in order to help the lawyers frame the issues properly? Do you ever get involved in drafting, for instance, on dispositive motions? And in what settings would that be appropriate to reach out to you for something like that?
Yeah. I think we want to be careful. We're always trying to kind of jealously guard our bandwidth just as a firm. We want to make sure we're not, because to do the kind of work we do well, we have to really focus on the arguments, just like you guys, want to focus on trials. You don't want to extend yourselves too much. So the most common situation where we're brought in the trial court is immediately after a verdict. We work, help with the post-trial motions. And I was just in Boston on Friday arguing post-trial motions, on punitive damages. That we do that a lot. I think it's less often, but it does happen that we're brought in sometimes even before the case is filed to help shape the legal arguments. And then for dispositive motions, there are people who will bring us in knowing that there's a really serious legal issue in the case, for example, forced arbitration or preemption, something like that. And we may be we'll agree that we're going to do the appeals even before there's a decision. And then we help shape the arguments. So that, that happens. It's a case by case kind of thing. But I think, I'd encourage people, we're always happy to talk to folks about their cases. But I would say, please don't bring your appellate lawyer in after the post-trial motions are decided. Try to bring them in before that, because that happens a lot. And there's just so much that the appellate lawyers can do to help the trial lawyers shape what the appeal is going to look like.
Yeah, I mean, I'm a big believer in that. We just used appellate counsel to manage post-trial motions in my recent verdict. And Rahul, I don't think I may have mentioned it, but we got them ordered just the other day denying all their post-trial motions. So But it's just such a relief, especially when some of the arguments address conduct that you personally were involved in. It's hard to go
Right.
back in front of the same judge and argue about something the judge may have been critical of, or and it's a nice weight off your shoulders to have to outsource that duty to somebody else and to have a fresh perspective on it. So I think that's incredibly valuable advice. What kind of things are you seeing to try, like repeat mistakes that you wish trial lawyers had not made that make your life more difficult when you get to the appeal process?
It's really easy to kind of be like this backseat driver, or like Monday morning quarterback is really the way to think about it, right? It's really easy for me to sit in my office and say like, oh, I would have done that differently. I will say like basically every appeal, we have things we see in the record where we're like, oh, that's too bad that it was done this way. It would have been better if it had been done this way. But again, it's like very easy to say that. It's very hard in the mix of things, in the fog of war. You're not going to get every legal argument right. But I think the most frustrating thing is preservation problems, when you really haven't taken the time to properly preserve the argument in a way that can be raised on appeal. And so we often have kind of debates over a waiver where we're saying, look, if you look at this footnote, or this sentence here, that the trial lawyers really did make the argument, and the other side's saying that they didn't really develop it. One really specific thing, and I think I mentioned to you guys when we were in Nashville, one really specific thing we're seeing is in big verdicts where there's punitive damages, where there's going to be a fight about the ratio on appeal, that plaintiffs' lawyers sometimes forget that you can put in evidence about not just the actual harm that your client suffered, but the potential harm that could have been suffered to by other people in that same position. And under the U.S. Supreme Court's case law, that can be factored into the ratio analysis. And so what you can do is effectively lower the ratio if you can point to that evidence. And that's something that we can't fix after the trial is over. So it's just like a tip. If you're going for big punitive damages, try to think about putting in evidence on that. You can have an expert put in evidence on that kind of thing, and it can really change the appeal.
What about talking about this preservation issue? We've got lawyers of all different skill levels and that listen to our podcast. What are some simple pointers? Because I know there's a lot of lawyers who just feel uncomfortable objecting in front of the jury. And there's some lawyers who want to object all the time, which could potentially alienate them from the jury or not. What's a easy way for people who are more reticent to object or over-object in front of the jury to preserve these issues for their appellate lawyer?
Yeah, I mean, look, this is one of the examples of why I think it's easy for the appellate lawyer to say, "Oh, why didn't you preserve that?" But when you're really in trial, you have, competing considerations, right? I'm not in a position to say you were wrong to not make the objection, that particular objection, in front of the jury. Maybe you're right that it would have alienated them, but it doesn't mean that you can't very quickly. Like in a sidebar, for example, make clear, on the record that you have that concern, right? That's risk-free in the sense that you're not, doing it in front of the jury, right? So I think it's just important to try to, do it as contemporaneously as possible and as consistently as possible. And then also, this is where it may be helpful, and I think we're increasingly seeing plaintiffs' firms do this, to have somebody in your firm or somebody on your team, the trial team, whose job is to kind of relentlessly focus on the errors, on the potential appeal. A lot of plaintiffs' firms have a law person. It doesn't have to be the person who's ultimately going to do your big high-stakes appeals, but that person is really focused on that, and that allows you to not have to focus on it as much.
What are you seeing on appeals regarding damages caps? Is there a trend in any generation? Obviously, it seems like corporations are trying more and more to tilt the playing field by changing the rules of the game and eliminating the jury's ability to award damages or limiting that in some way. Are we having any success in challenging those things?
Yeah, I mean, I think we're living through a kind of second big wave of tort reform, and we may be at the beginning of it. I think there were a lot of fights about this in the 90s. Like, if you think back to the 90s, tort reform was discussed in presidential debates. It was a big political topic. When I teach law students now, they don't know that. They don't have the same perceptions of the civil justice system that those of us who are a bit older do. And I think we're seeing this. This is Rahul. This is, I think, when you and I first met, was dealing with, it wasn't damages caps, it was an attempt to cap attorney's fees. But we worked together on this effort in Nevada, where Uber was proposing a ballot initiative to cap, this is crazy, cap contingency fees in all civil cases in the state at 20%. And it was pretty scary because, it's Uber, they have a lot of money. This is a long fight for them. And, if they get it on the ballot, it's hard to fight that. People don't necessarily love lawyers and legal fees. And we were able to defeat that initiative. We sued them and we brought it to the Nevada Supreme Court and we won. And
it was amazing, and just
I'm proud of this fight. It was a great team effort, but
it was Deepak's brainchild, though. I mean, you found the issue, you framed the issue, and you won the issue in the Nevada Supreme Court, and got that ballot initiative stricken. So Uber wasn't.
How did you do that? I mean, we don't need the full explanation, but the short version.
Well, I got a text message from a lawyer and said, "Can you do a constitutional challenge to this ballot initiative?" And the short answer, I looked it up, is no, you can't, because it's not a law yet. But there's this narrow window where you can run into court and you can sue based on the description of the initiative. And we did that really quickly. We dropped everything, and we got 50 declarations from lawyers across the state and experts. And we called the case Uber Sexual Assault Survivors for Legal Accountability versus Uber. So that was the caption of the case when it ended up in the Nevada Supreme Court. They didn't like that very much. And, we said it can't be a coincidence that there's this big multi-district litigation about sexual assault against Uber, and they're trying to cut off the ability of everyone to get into court, including survivors. And then, I think we made legal arguments. We made technical legal arguments. I don't have to detail the technical legal arguments about the problems with their description, but I think it was also about, a recognition that the state judiciary there is not going to like this big, powerful company coming into the state and trying to wreck the state's civil justice system. And I think, Ben, you asked about how are we doing with damages caps and how are the courts treating these tort reform issues? I think it remains to be seen, but the story from the 90s was that the state Supreme Courts were pretty hostile to a lot of these caps, and there are a lot of good wins, including under state constitutional law. And I'm optimistic. We're starting to see a wave of these challenges, and we're getting involved in some where I think the state Supreme Courts in particular have an important role to play in protecting the architecture of the civil justice system. But it's a pretty dangerous new wave because these companies they're willing to put a lot of money into it. People do not understand the role of contingency fees. People do not understand how it affects them. This is playing out in California now. The Uber has a ballot initiative there as well. And they made an interesting mistake there of in the multi-district litigation, the sexual assault litigation, They tried to get discovery into Consumer Attorneys of California's political campaign, and they tried to get an injunction to stop their political ads. It's pretty interesting what happened in California. Uber's lawyers at Kirkland and Ellis filed this extraordinary motion before Judge Breyer in the sexual assault multi-district litigation. And they asked Judge Breyer for a prior restraint on speech. They asked him to enjoin Consumer Attorney of California's political advertising about Uber's sexual assault problem in this ballot initiative fight. And furthermore, they asked for discovery into CAOC's political campaign, which was just an incredible overreach. And I think, it just kind of plays into our narrative about what Uber is doing, which is that they're trying to silence survivors, and in this case, silence the lawyers and the advocacy group for the lawyers that are trying to defend the civil justice system. So we went in, our firm came in to represent Consumer Attorneys of California. And I think actually, Rahul, this started, I think
Yep.
you're the first person I talked to about this, I think.
Yep.
And we got Judge Breyer to reject that request. I think that's just like one skirmish in a really big fight that's playing out right now in California. I know you've been really involved in that fight.
And you touch upon something and it resonates, which is this wave of tort reform, and what we're experiencing firsthand is one of the tips of the spear is clearly Uber in this wave, in what they tried to do in Nevada, and you helped thwart, Deepak, and now what they're doing in California. And they're starting to plant the seeds all over the country with different types of steps being taken in New York and other places. And so, at least here in California, we, and by we, I mean the plaintiff trial bar, has been very galvanized in trying to protect consumer rights, and have been raising a significant amount of money so that we can fight Uber and make sure that they don't take away victims' rights, take away access to the Seventh Amendment and the right to a jury trial. And whatever happens in California has an impact across the country. And so, since we've got a national base here, I'm just calling out for help, that any lawyers across the country who can help with their time financially to defeat Uber, please reach out. Please let me know, and then I can let you know where you can provide that support.
Yeah, it's such an important fight, and the work you guys have been doing to raise funds and awareness is so crucially important. And I think this is the beginning of a wave. It's these ballot initiatives, it's new legislation. They are bringing lawsuits against lawyers and law firms, RICO cases. There's public messaging. It's happening all over the place. And I do worry that the plaintiffs' bar, sometimes we are a bit fragmented. And so we tend to see what's happening in a particular state, but it's difficult for us to see the whole picture. And so I think it's really, really crucial for people to share information. I've been talking about this at AAJ a bunch, to try to make sure that we're one step ahead of them.
We should have you back on, Deepak, and Ben, if you think this is good, we should do a whole segment on, eyes wide open on all of the different attempts by those in positions of power, the big corporations, on their tort reform strategies, and what they really mean versus the dog whistling that they're doing out there.
Mm-hmm. Yeah, and maybe like one other person, I could suggest one or two other people if you want, like if Nora Engstrom at Stanford Law School, yeah. But I think it's such an important topic. Yeah.
Well, Deepak, this has been really terrific. I'm so glad you made time for us. Just one final question, because I'm sure many of our listeners would be interested in knowing this. How do you guys, what's the compensation arrangement if you guys become involved in a case? Do you share in the contingent fee? Are you an hourly rate? Is some combination of that? What?
Yeah, I mean, I think this is one of the things I had to figure out, and we sort of made it up as we went along. But yeah, we are plaintiffs' lawyers, and so we like to be aligned, not just in our values and position, but also aligned in the structure of compensation with the people that we're working with. I think that's the best way to do it. I don't want anyone ever thinking that I'm like charged. The meter is running when they call me to ask a question or try to figure out a problem. And so I think the hourly billing model just kind of is a terrible idea. The incentives are all wrong. So we try to do contingency. I think it's really easy if somebody comes to us with a big jury verdict and they want us to take it on. It's very easy to say we'll do that on contingency. I think it's more difficult if a case is at its lowest point and the case is worth zero, and lawyers always want to share their contingency when the case has been tossed out and is worth zero, and we have to figure out a model that makes sense. So what we often do is a hybrid model where they'll pay us something and then we'll take some contingency, and then we have to do an assessment of the likelihood of success, not just of the appeal, but of the underlying case. So we're flexible about how we do that. But yeah, we're plaintiffs' lawyers, and we like to be aligned with our co-counsel.
Well, you certainly have an incredible track record. I hope you're on contingency in the Monsanto case with Rick Friedman, getting his $1.6 billion restored.
Yeah,
that was a remarkable achievement.
It was a great fight. Yeah. And I mean, some of the best trial lawyers in the country. I mean, such a privilege to be able to work with, really fantastic trial lawyers, and also like kind of humbling. I mean, it's a big deal when somebody has won a landmark case. It's an awesome responsibility to the plaintiffs and to the trial counsel to make sure that you protect that. And and in those cases, at one point, the Intermediate Court of Appeals issued a decision that would have blocked those verdicts, and we had to get it reinstated in the Washington Supreme Court. And so the stakes were pretty high. I can't tell you how relieved I was.
I'm sure Rick was equally relieved, or more relieved.
There's a friend of mine who said, like lawyers are either they're people who love to win or hate to lose, and I think that I am. I think I might be in the hate to lose category. So like I feel incredible relief when the universe delivers the right result.
Oh, well, thanks for joining us, Deepak. If anybody wants to reach you, what's the best way for them to do that?
They can email me. Our law firm website is guptawessler.com. They can email, they can call. And I like to try to get back to people. Love to talk to trial lawyers. And people should reach out. Yeah.
Thank you.
Thanks for having me, guys.